How to apply for a green card via consular processing by CitizenPath. Consular processing refers to the various steps to obtain a U.S. visa through a U.S. embassy or consulate abroad. This video specifically addresses family-based immigrant visas, also known as green cards. There are two fundamental ways to apply for a green card: adjustment of status and consular processing. Certain intending immigrants who are also inside the United States may be able to apply for a green card through adjustment of status, but the vast majority of green card applicants use consular processing. For family-based green cards, the consular process actually starts with the U.S.-based relative. U.S. citizens and lawful permanent residents or green card holders may petition certain family members for a green card. The petition serves two major purposes. It documents that the beneficiary and U.S. relative have a qualifying relationship, and it establishes a priority date. That's the beneficiary's place in line for a green card. Immediate relatives always have a green card available. Immediate relatives include the parents, spouse, and unmarried children under age 21 of U.S. citizens. But Congress puts a limit on the number of green cards issued each year for other types of relationships. That's why there's a wait. USCIS processes the I-130 petition on a first-come, first-served basis. For an explanation on the types of qualifying relationships and how long each one takes, use the links in the description of this video. To start the process, the U.S. citizen or permanent resident must file a petition package with U.S. Citizenship and Immigration Services. The package includes these forms: I-130 Petition for Alien Relative, I-130A Supplement if the beneficiary is a spouse. How do you ensure a smooth process? Prepare your petition package correctly and include the appropriate supporting documents. If you are starting this process, you likely have many more questions. Go to citizenpath.com/CP to learn more about the process and to get started on your journey. Again, approval times depend on the relationship. Once USCIS approves the petition, the agency will forward it to the National Visa Center. The NVC coordinates the transfer of your case to the U.S. consulate in the country where the beneficiary resides. It's important to point out that a Form I-130 approval does not grant the beneficiary the privilege to begin living and working in the United States. During this time, the beneficiary generally may enter the U.S. on a temporary non-immigrant visa, like a B-2 visa. But the beneficiary must depart once the visa expires. The I-130 petition is not the application for a green card. That comes next. Once the I-30 is approved and a visa is available, the NVC instructs the beneficiary and petitioner to submit additional items such as immigrant visa application processing fee and affidavit of support fee. Immigrant visa application, also known as Form DS-260. Financial sponsorship from the petitioner, also known as Form I-864, affidavit of support. Once the NVC has gathered all the required items, they can forward your case to the embassy or consulate. At this point, the beneficiary attends a medical exam with an embassy-approved doctor and an interview with a consular officer. If all goes well at the interview, the beneficiary may leave with an approval. Did you find this video helpful? Subscribe to CitizenPath for more content that will make your immigration journey easier.